Ready on Anthony Goodall.
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Anthony Goodall, 24-03541. Appearance for the record, please.
Good morning, Your Honor. Casey Martarian appearing on behalf of
Here, Robinson, Assistant Public Defender for Mr. Goodall.
Okay, Mr. Goodall is present from Ingham County Jail. Today was the date and time scheduled for a probable cause conference on motor vehicle UVA, police officer fleeing and eluding a police officer assault. Matter is scheduled for preliminary examination next week, December 19th at 8:30 in the morning. Are we continuing to examine?
We are, Your Honor.
An offer at all?
Yes, Your Honor, there was an offer. It's a global resolution offer. Mr. Goodall has a few cases pending at this time. He has a larceny in a building matter set in the 55th District Court with Judge Hellman for PCC this week, PE next week. He has a retail fraud second, also set with Judge Hellman for pretrial next week. He has an entry without permission case set for pretrial in front of Your Honor on the 17th. We also noticed yesterday after sending this email, he has a retail fraud second case that is in review, has not been issued yet at this time. The global resolution offer is to plead guilty to the larceny in a building charge, as well as the motor vehicle UDAA charge on this case, with restitution reserved in any of the files once it's determined. In exchange, we will consent to HYTA status and dismiss the balance of his files, as well as not issue that retail fraud second.
Yes, Your Honor. That is correct. That is what the offer was. We would like to address bond mode today.
So we'll continue to examine. Mr. Goodall will be in person next week at 8:30 in the morning. You can address bond.
Yes, Your Honor. We'd be asking to convert the bonds from a 10% bond to a PR bond. Mr. Goodall has a place where he can stay. He would be living with his mother at the Spinnaker Drive address, which I believe is in the file. He does also have a working phone number and has been in communication with us. He understands the importance of coming to court, and I have spoken to him about the requirements of bond. We'd be requesting a personal recognizance bond.
He was on probation and or parole or had other pending matters at the time that these allegations took place,
I don't believe that he's on probation or parole.
or had other matters, criminal matters pending, meaning he was under a bond order when these allegations took place, correct?
I have to double check the dates because they were all following at the same time.
I see here in the bond recommendation for him, at minimum, it looks like he had been sentenced on a retail fraud case on October 15, 2025. And it states here that he had other matters pending at the time of this matter, or that he was on probation, which would make him ineligible or not as a candidate for a personal recognizance bond. Bond is rather low, 4,010%. We'll continue. Any additional matters for the record?
No, Your Honor.
They're all set, Mr. Goodall. And we're continuing on with the Lazo Beltras.
That's correct.
Is that an interpreter matter?
I'm here, Your Honor, on behalf.
Interpreter is free to go.
You don't need an interpreter, Your Honor?
It doesn't appear that one is needed.
Okay, thank you.
Thank you. Let me see, is Lazo Beltras here?
She's right there, Your Honor.
Okay, she's free to go. You don't need to go on the record on that one, correct?
Correct.
She's free to go. Is Jacob Mullins here?
Doesn't appear to be the case, Your Honor.
Have you had contact? Have you had contact at all?
Probably.
Seven.
If I could explain. I reached out to really the only means we have of contacting Mr. Mullins, which is a phone number. We were not provided an address or an email address. I called that number. The person who answered confirmed he was Mr. Mullins, but then quickly disavowed that and claimed that he was not Mr. Mullins. He knows who Mr. Mullins is, but says he was not Mr. Mullins.
Wonderful.
Pretrial services had a similar interaction in that they called the same number that we had. The person admitted to being Mr. Mullins, but then said, no, I'm not Mr. Mullins. I had a approximately 10-minute conversation with this person that was rather incoherent, disjointed, and just mostly consisted of nonsensical ramblings. From speaking with the assistant public defender that did his arraignment, indicated that he may have some mental health issues and a competency referral would likely be needed. If Mr. Mullins had appeared today, that would have been my intention. I've called the hallway, no one has answered to the name Jacob Mullins when I called. I would say based upon the totality of the circumstances, it's likely that the person I spoke with was Mr. Mullins.
Okay, sounds good. It looks like at the time of the arraignment, he did not provide. He said he wasn't sure of the address. When asked if Thomas, not sure what that note is.
I'm sorry, Your Honor, what was that note regarding the address?
When asked if Thomas, says could be. Oh, I don't know what that means. There was a phone number in the file. We don't have the fingerprints. I'll show bench warrant on that one.
And that is an immediate bench warrant or 48 hours old, Your Honor?
Immediate bench warrant.
Okay.
Thank you.
Seems like you did a good job.
Mr. Goodall, you're all set. Muted. Let's see, you're muted, so we can't hear you. You may need to get a deputy to unmute your device because I can't hear you.
In 30 seconds. Yeah, I was
Okay.
saying, I didn't exactly know what was going on in my case. I didn't hear you guys.
Okay, your matter is going to continue to exam next week. It looks like there was an offer for a global resolution because you have multiple matters pending in this county. And then your attorney did make a motion to amend the bond to a personal recognizance bond, to which the court denied because at the time of these alleged incidents, you were already either under a court order for bond or on probation or parole, okay?
Okay.
Your bond at 4,010% will continue, and then we'll see you next week for your preliminary examination date, okay?
All right, thank you.
You're welcome. Okay, and who's in post 1 from the jail? Sir?
Carter.
Okay, Jayland Carter. That's Ms. Donnelly's name. Who's representing, Mr. Goodrich is here for Catherine Place.
Attorney General case, Your Honor. Mr. Hayes.
Sounds good. On the record in the matter of the people of the state of Michigan versus Catherine Place, 24-02112, counsel with parents.
Good morning, Your Honor. Robert Hayes, Assistant Attorney General, here for the people, P69 006.
And Attorney Luke Goodrich from the Public Defender's Office, here to represent Ms. Place, who's appearing over Zoom today.
Okay, Mr. Place, today was the date that was scheduled for sentencing. I do have a pre-sentence report with a recommendation as to how you are to be sentenced. That report was prepared back on December 3rd. Counsel, did you get a copy?
I believe so, Your Honor.
Yes, we did, Your Honor.
Do you need to make corrections, updates, or deletions at all?
Nothing from the people.
Nothing from the defense, Your Honor.
Make our motion.
Your Honor, the people only have, that's restitution as requested.
Your Honor, from the defense, Ms. Place, she is 39 years old, has never had a matter with the criminal justice system prior to this incident. She was working with the state of Michigan. As a result of this incident, she lost her job with that position. Since that time, she has been able to get employment doing substitute teaching. However, the school is aware of her situation here, and they're basically have told her that if it's all done today, then they'll continue. However, if she's on probation or there's more things going forward, then they would likely end that employment. Your Honor, there was a restitution amount. My client posted that as a bond at the time of the plea in order to do the plea. So that money has already been placed in the hands of the 54 District Court. We would just ask that be ordered to be dispersed to the victim in this case, Mr. Baker. So with that being the case, Your Honor, we would just ask that you sentence Ms. Place to fines and costs in this matter. She has certainly suffered significant hardships related to her employment situation and the fact that she's already taken care of any restitution, Your Honor. Thank you.
A couple of things. I need a restitution sheet completed. Do we have restitution form put down there? Should be like a red or pinkish color. Yep, that needs to be completed. The other thing is, the file says that the bond was personal recognizance.
We went to the counter, Your Honor, and we posted a special bond for the exact restitution amount.
But they not updated the file, the physical file of the receipt. Website. See that in the system. No, no.
Just to let the board know, I was here with Ms. Place when she did that. That would have been on September 26th, the day before her.
See anything in monetary transaction 674.32.
That is it.
674.32. I just need a restitution form, and then I can apply that. Does your client want to make a statement?
No, Your Honor, she does not.
I reviewed the pre-sentence report and the recommendation, as well as Ms. Place's prior criminal history, which, as indicated by your attorney, Ms. Place, there was no prior criminal history. The concern the court has is how does one go almost 40 years without having any interactions with the court, has a good, stable employment as a governmental employee, and then one day makes a decision such as this to compromise themselves. I mean, not to say that any crimes are smarter than the other. This has to be the dumbest crime ever. Like, it's easily traceable. It made zero sense to me. And the report from probation was that the details from the police report were significantly different from what the defendant stated during the pre-sentence interview. Why is that, Ms. Place?
I don't, can you hear me?
I can hear you.
Okay. It was just a simple, honest mistake. I was working too quickly. I was booking stuff for spring break. I had everything wrote down and I just transpired the numbers from up and down. I didn't have everything labeled like I should have. And that it was my mistake. I didn't realize it at the time until after the effect.
And Your Honor, just to clarify, she did the plea factual basis based on the fact that she realized that mistake and then didn't take any action to essentially return the person's money and essentially hung on to it at that point.
How is it that you accidentally used someone else's credit card number?
How did had it wrote down on the piece of paper along with my credit card number, and it was on the top line instead of the bottom line. And when I was putting everything in, I realized it after the fact and I didn't know what to do. I mean,
Why
looking
would
back,
why would your credit card number be written down at work?
because I was getting a new credit card through MSU Federal Credit Union, and my mom had sent it to me, and I was booking stuff for our spring break trip that day.
Okay, and then in your duties at work, you have access to other people's credit cards? Is that accurate?
So when at the time when the person called and said they were double booked, double charged for a license, we were told to take the credit card number down that they used, they would be refunded, and to send it to our manager at the time. And that's what I did. I had wrote it down. I had sent her a message in Zoom stating, this is the number, everything like that. It was conversations going back and forth. Everything was wrote down on a scrap piece of paper.
And I hear what you're saying. Still makes zero sense to me that if I'm at work and I have some level of fiduciary responsibility to other people's information, I would not put my credit card number down on a piece of paper where I put somebody else's credit card number down. It just makes no sense to me. The other concern is I recognize how we elicited the factual basis, but once you did learn of such error, which I'm sure should have been rather soon, in short order from you booking the tickets, it's something as simple as canceling the tickets could have resolved that and notifying the owner of the mistake. But it only further makes me disbelieve your version now because of the fact that there was no actions taken to correct the issue. The recommendation of the probation department is that you scored a low risk on the dynamic risk and needs assessment, but that it would be appropriate for you to have a term of probation, primarily because I think he believes that the discrepancies between your rendition of what happened versus the police report, just they don't align. And I tend to agree with Mr. Neves when it comes to how this information registers as something as a logical mistake or not. The court's going to adopt the recommendation. We're going to impose a term of 6 months probation. While on probation, you have to maintain employment. And I recognize your current employment status may shift as a result of this incident, but you'll be required to obtain new employment. Also, while on probation, you're not to engage in any assaultive or threatening behavior, not to purchase a firearm, ammunition, or weapon of any kind. I'm not going to order PBT testing. And the amount of restitution, as stated on the record, that was posted as a special bond will be applied to the balance. I'm not going to require she report monthly for probation at this time. There's a $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost that also must be assessed. And a $250 fine that will be assessed. And you can make monthly payments on that, okay?
Okay.
Yeah, any questions at this time?
No.
You will be required, of course, to provide evidence of employment. That's really the only requirement that I'm issuing to you. You're not going to be reporting. I'm not going to make you do tests and drops. You will, however, need to find some stable employment, okay?
Yes,
Okay. Do you have any questions at this time?
no,
Lastly, there's an advice of rights as to probation. You've been placed on a term of 6 months probation before the 54A District Court, and your terms are specifically tailored to address your assessed risks and needs. You do have the right to request early discharge from probation once you completed half the time ordered by the court, so long as you're in compliance with the court, you've not had any violations, okay?
okay,
And you would just make the request by using the court's NC 512 form. That's the form for regarding notice for eligibility of early discharge from probation. That's on the court website, or you can get it from our probation department directly. You will make a copy of that and serve it on the AG's office. You ready with that? Or you're not? On the AG's office, and then also a copy on probation. The AG's office will have 14 days from receipt of that notice to make any objections to your early discharge. I don't believe under the circumstances that will happen. And then with, if there for some reason is a hearing scheduled to address the request, you have the right to hire an attorney to represent you. You do not have the right to court-appointed counsel for early discharge from probation. You understand that?
okay,
I've never held a hearing for early discharge. I've reviewed it based on the motion. Do you have any questions at this time?
no,
Okay, so your total fines and costs are going to be $375. Again, you do have the option of making payments on that over the next 6 months. That's approximately about $62. Council, was there an issue with the restitution?
There's not an issue per se, Your Honor. I just want to make sure I fill out correctly. Can I send it to the court either later today or tomorrow? Just
No problem. No problem. I can't apply it unless I have that on there.
part of the thing is I want to make sure that it goes to the right
The right
person or
person.
entity, depending on who is reimbursed and who's not.
Very good. Can you give me the amount again?
$674.32.
$674.32. Okay, I'll note that here, and then once we get that form, they can apply it. Any additional matters for the record?
Nothing with the people, Your Honor. Thank you.
Your Honor, I just had one question myself. With non-reporting probation, does this place ever need to meet with probation to go over orders one time, or is she?
She does need to meet still to go over the orders of probation.
Okay, so she would need to call probation and meet with them one time and then go from there.
Correct.
Okay.
would it be the same person I already met with?
Yes.
Correct.
Yes. Okay, any additional questions or matters for the record?
No, Your Honor.
Thank you, Your Honor.
Thank you, you're all set, Ms. Place.
Okay, thank you, Your Honor.
Thank you. Let's see.
Your Honor, I just want to confirm we're moving Nazardine.
Hughes. Both.
Pardon me?
Nazardine, I do have a step to adjourn, is my understanding. I received that yesterday and I said that it would be granted.
Okay.
I don't know that we gave you a detail. Here's the file. Let's see here, we can get your date now. Let's see, out of state. Okay, so any date in January or our next available date will be fine. I'm assuming. February 7th at 8:30.
Good. Thank you, Your Honor.
Thank you.
Appreciate it.
No problem. Have a good one, be safe. Let's see, Mr. Silver Brunson is set to adjourn on Hughes.
Did you just email that?
Let's see here. No, I don't think I did.
No, he didn't stipulate to adjourn, Your Honor. He hadn't had a chance to speak to his client, so he wasn't in a position to where he could really
Okay, so we'll
stipulate.
take that on the record.
Yeah.
Okay, and then Salzman,
I believe Mr. Feigelson was recently appointed for that one.
Mr. Feigelson. On Zoom, but he's not responding. And then Jayland Carter. I don't know where his attorney is.
Jayland Carter.
Miss Donnelly is what's noted on
I
there.
have not seen her today at all.
All right, let's see. Mr. Feigelson, are you there? Let's see. Mr. Carter, your attorney is not available. It sounds like she's tied up in another courtroom, so I'm resetting your sentencing.
Okay.
Let's see. I have a date to reset this.
January 2nd at 9 a.m.
Is that the next available date? We could add a slot somewhere soon for that. Next week, the 20th should be good. You can add
I have the
something
19th,
on the 19th.
Yep.
Okay.
9 a.m.
December 19th at 9 a.m.
Okay.
You're all set for today, sir.
The time on that again.
9 a.m. It's for the record. Okay, you can call that your client.
He's in custody. I just got done seeing him while he's here.
Okay, you want him brought up. Do you want him brought up for this? I didn't know if you were over stipulating.
Yes, because I was explaining to Mr. Cherry.
Okay, that's fine.
Clients,
Objecting.
they should always follow our advice, then they probably wouldn't be our clients in the first place.
Again,
I
he
have to
doesn't
make
have
that.
to understand. We don't have to follow everyone's advice, right?
Right.
Let's see here. Hughes, we can bring up Hughes. Mr. Feigelson, can you hear us? On the record in the matter of the people of the state of Michigan versus Marcus Dwayne Hughes, 24-01865 FY council appearance.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Good morning, Your Honor. Dwayne Sullivan, now public defender on behalf of Marcus Hughes, who is standing next to me at council table.
Mr. Hughes, how are you? I'm well, thank you. Okay, today was the date that was set for a preliminary examination. And my understanding is that there was a need to, or request, I should say, to adjourn this because of a co-defendant. Is that the issue?
Yes, Your Honor. Since the initial stages of this case, we have had a Sadie Cook as a possible suspect. She has now been charged, as it seems in my file. It looks like the case was filed with the 54A District Court yesterday. So for those reasons, we would be requesting to adjourn this preliminary exam in an amount of time that would allow enough time for Sadie Cook to be arraigned on the charges she's now facing. And so that both of these matters could be set to run at the same preliminary exam. Most all of the witnesses, facts, incidents, everything about these cases overlap. So for the sake of judicial economy, it would make no sense, in my opinion, to split up the exams rather than to run them all as one co-defendant exam with all counsel present for all parties involved in this incident. So I would be requesting to adjourn. I think maybe even if Your Honor would give an early January date, that could work. My only concern with doing it in the next 2 weeks is that I will be out of town. This is a somewhat complex case, so I don't really want to pass it off to someone in 2 weeks notice.
I don't have a docket after the 20th. I'm off the rest of the year, so that wouldn't be an option anyways. Mr. Silverthorne.
Yes. I met with Mr. Hughes actually a couple days ago to prepare for this exam, and I met with him again this morning indicating that the prosecution was going to again request an adjournment of this matter, and my client would like it dismissed. He understands it's without prejudice. He understands that it can be brought back. He's been in jail for 6 months on this. This has been adjourned on multiple occasions, mainly because of the lack of available victim witnesses. We don't believe that one of them can be found and the other one is not here today. In terms of Sadie Cook being charged, I got this incident report in this case because this has been pending for like 6 months. 6 months ago, probably within 15 minutes of getting that report, I identified her as a likely defendant. I don't know what's taken the prosecution so long to finally charge her. We would similarly oppose any request for adjournment or starting the PE on that basis, because if that could have been done when we were here the last time and didn't have the victim, we could have at least started it. We believe that it's stalling. Having said all this, I will also indicate, and I told Mr. Hughes that I would put this on the record, that my advice to him was the adjournment, but it's purely practical. It wasn't not aggressively defend him. It wasn't a defense because it wasn't defending rights. It was simply practical because he's under sentence in Livingston County and in Oakland County, with one of the sentences not ending until next month, and the other sentence not ending until June. I told him that if this case is dismissed, it would be, of course, without prejudice, because there wouldn't be any adjudication. And that technically, although he'd still be sitting in jail, he wouldn't get any jail credit for it because he wouldn't have an existing case until it got reissued. He understood, he said he understood all of that. I also indicated that if his case did not get combined with Sadie Cook's, I could not guarantee that I have the opportunity to cross-examine Sadie Cook, because what if I'm in trial? Because I'm not representing her. That if the trials on FJPs are consolidated, the cases are consolidated, however, I would have that opportunity. You understood all of those arguments, is that correct, Mr. Hughes? In understanding all of those, he wants me to oppose the request for adjournment. And I'm doing so now. Thank you, Your Honor.
Thank you. That's why you have an attorney, because he can think through things that you don't understand. Or maybe you do understand, but you don't understand why it makes sense the way he said it. You think your way works better than what he advised you of? You think it's best to just go ahead and dismiss, because they're gonna reissue this, you're still sitting in jail, which means you're gonna be brought back over here to be arraigned. Your bond is 100,000 cash ready now, it could be 200,000 next time, because a different judge is going to arraign you. We don't know what the bond could end up being. It's more paperwork for the court, which is unnecessary. This matter was not adjourned multiple times because of the prosecution. First time it was adjourned was because of the defense. The attorney didn't show up, he was in trial. So I had to find good cause. I couldn't even wait the 21 days to reset it because I had no attorney to advise him of why it was being waived. And so then there was a judge, I had a conflict. So I had to reset it to October. And so October, there was officers in mandatory training, which is outside of the prosecution's control, if there was mandatory training. And so it was reset for this date. There's a co-defendant. You've got 2 counts of assault with intent to murder on 2 separate individuals. 2 counts of weapons, firearms possession. Well, actually, one is discharged from a vehicle. The other was firearms possession by a prohibited person. And then you have 4 felony firearms and an habitual offender. 4th offense notice, you're facing life if the primary offense has a maximum penalty of 5 years or more, 15 years if the primary offense is a penalty of 5 years or more. So you're facing life in this matter. Very easily, your bond could be higher than $100,000 next time. And you think that dismissing it today, where you're not going to get any credit for any time that you're sitting, to have this reissued for us to get more paperwork, just to get us right back where we're going to end up anyways. You think that's the best idea? The court's going to deny the objection. It's noted. It's in the interest of judicial economy that this matter be reset, because the prosecution is making it very aware. The only way the court can dismiss this is without prejudice. That means that they have the right to reissue it. They'll have it reissued before the weekend. I can guarantee you that, which means I'm the on-call judge. I'm going to re-sign it again. And then I'm going to see you this weekend when I'm here to arraign you again on this. And I'm giving you, I didn't arraign you. I would have given you a higher bond than $100,000. You understand that? You don't understand that? You don't understand? What part do you not understand?
I don't understand this whole case, but yeah.
No, I'm not asking if you understand the case. I told you, you were arraigned. I said I said you understand what would happen if the case was dismissed. If I grant your request that and dismiss the case, you're likely to end up in a worse situation, is what I'm telling you, because they were going to reissue it anyways. So this case is still going to end up pending. If I had arraigned you, I would have saw these charges, saw this bond recommendation, looked at your criminal history, and I probably would have given you a higher bond than $100,000. So dismissing it is not really in your best interest, is what I'm telling you, because the case is still going to pend. It's not going to make the case go away. It's just going to stall it by dismissing it, because they're going to reissue it this week. And now we got to do more paperwork, and then I got to rearrange you this weekend. So I'm not going to do that. I'm going to grant the request. The case was issued. Do we know who Drew Sadie put the case?
It was just filed with the district court yesterday, Your Honor, so I don't know if it's been assigned to the judge.
If it was filed, then it automatically went. If it went in the system, it automatically spits out a judge. Cook, Sadie Cook, SADIE. I don't see it in our system. Okay, we don't see. You said it was filed, or?
That's what our PBK system says, Your Honor, which is supposed to communicate with JIS, but we have had some delays in that. What I see on my end is that it was authorized, it was sworn to yesterday, and the last note I see is that the case was filed to district court. I don't know if that's 54A or what, but I can double check on that when we get back to the office. It has at the very least been open authorized.
Is there a jurisdictional issue where it would have went to another court? Said not before.
Not that I would,
Oh.
not that I could see.
I don't recall signing anything for city clerk this week.
I have a CTN if you'd like, Your Honor. That's all I have at this point. That was the
Oh, yes.
CTN for it is 332-400-333-701.
Okay, I'll have that up pulled to make sure it's reassigned if it was not automatically already assigned to me. And then we'll get you a date in January.
Thank you.
January 10th. January 10th at 8:30. Do you have any questions for the court today, Mr. Hughes?
Would you like to address the
That's up to you. If you have questions, something that you don't understand, I can't explain the charges to you because I didn't bring the charges against you. You were already arraigned, so they went through what the charges and allegations were. But do you have any questions other than that? You don't know if you have any questions? at
I
this
will
time?
visit with them
Okay.
following this hearing, and I'll go back down to the.
Sounds good. A bond at 100,000 cash surety with GPS tether and no contact order will continue. Any additional matters for the record?
Nothing from the people.
Thank you.
Thank you. You're all set. Mr. Feigelson.
Yes, Your Honor, I apologize for my stepping away. I had to go in front of Judge Dragon check on a sentencing.
On the record in the matter, the people of the state of Michigan versus Brett Salzman in 24-02833, counsel appearance.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Brett Salzman, who's appearing via way of video conferencing this morning from, he's at the Pinnacle Recovery House, Your Honor.
Okay, yeah, today was the date scheduled for a probable cause conference. My understanding, Mr. Feigelson, is you were recently assigned this case.
Correct. About 3 weeks ago, I understand that Mr. Salzman had explored the opportunity to have this case be transferred to Judge Allen's sobriety court in the 55th District Court. I believe he no longer wishes to explore that option. I believe we'd like to have a preliminary exam on this matter. I don't know if it's scheduled for next week or not, but whenever the court's available for an exam, we'd like our preliminary exam.
I have a preliminary examination scheduled for December 19th at 8:30 in the morning. So we'll continue to that date and Mr. Salzman will appear in person. Any
Thank you, Your
additional
Honor.
matters? No problem. Any additional matters for the record?
One moment, Your Honor. I'm just checking to make sure we got subpoenas up for that date, because I don't know if we have that date. up.
I gave that date back on
Yep.
October 18th.
No, it's in there. For some reason, somebody at our office canceled it. So it must have been an error with our clerks. I've had good contact with the victim on this one, though. I shouldn't have an issue getting her here, even if we're not able to get a subpoena to her. So.
Okay, if you can confirm that as soon as possible, then that way, if we need to change it, we can let Mr. Salzman know before he appears. Okay?
Yes, Your Honor. And maybe the reason why it's showing that way is I think this was set for a PCC, but was supposed to be treated as somewhat of a review date. So maybe that's why we didn't get subpoenas out, but I'll confirm that. when I get
Correct,
back to
because
the
he was
office.
supposed to be transferred
Yes, Your Honor. So December 19th at what time, Your Honor?
at 8:30.
Thank you. Nothing further.
Anything else for you, Mr. Feigelson?
None, Your Honor. We'll see you in the morning and we'll see you next week. Thanks, Judge.
You have a good one. You're all set, Mr. Salzman. Bond continues. Let's see. Where's Ronnie Williams downstairs?
Yes. I understand it.
Did you speak with him already?
I didn't even know. I don't show him being in custody. Are we sure it's the right Ronnie Williams? Because there actually
There are
is.
multiple Ronnie.
There are multiple Ronnie Williams.
How many Ronnie J. Williams are there?
There's at least one other that's 56.
There is another one, yeah, actually.
And he is an ICJ.
Okay, well, maybe it's not. Mr.
Hmm?
Williams.
Mullin, Oliver.
Yes, good morning.
Good morning. Mr. Fuller is here in person.
Okay.
We can get
Am I
him
able
on
to
Zoom.
speak with him?
Yeah, we also say we can get him on Zoom so you all can speak privately about either resolving this matter or completing the joint pretrial statement. I don't know if anybody from my office sent you our standard form or not.
I'm not seeing one.
Okay, I'll have that sent and then we'll get him on Zoom in just a moment.
Thank you.
No problem. You come up to the table, sir. On the record in the matter of LENV funding versus Joshua Fuller, 24-04681. Counsel, can I have your appearance?
Morning, Your Honor. Lynn Olivier, appearing on behalf of plaintiff.
Okay, sir, state your name for the record.
Joshua Lundy Fuller.
Joshua Fuller is present in the courtroom. Today was the date that was scheduled for pretrial. This is for a general civil matter. Did the parties come to a resolution at all, or are we proceeding with the pretrial?
Your Honor, the parties request this pretrial be adjourned for at least 60 days. The defendant claims that this account was opened by his ex-wife. He says he sent to the court copies of W-2s. My office did not receive those copies. What I'd like to do is have my office send to him an affidavit of fraud for him to complete and return to us. We'll then send it to our client for determinations to whether or not they agree that it's fraud. And if so, we'll be sending him a stip to dismiss. If the client doesn't agree, then at the next pretrial, if then we could go through the pretrial statement, that would be great.
Sounds good. Let me get your date, 60 days out.
February 23rd at 2:30.
February 24th at 2:30.
February 24th at 2:30?
Yes.
Thank you, Your Honor.
No problem. So do you have any questions for the court today?
Oh, no, ma'am, not on the top of my head.
Okay, any additional matters for the record, counsel?
No, Your Honor.
We're all set. We'll get your notice to appear, sir.
Thank you.
You're welcome.
I was putting it in my phone right now, so I didn't.
Very good.
Thank you. Have a good day.
Same to you.
Thank you.
Do you need anything else from me?
Not for me. You're all set, sir.
Okay. Am I gonna get it mailed or should I? wait?
It's gonna print out in just a moment.
Okay, thank you so much.